Good morning, everyone. Welcome to the National Press Club, the place where news happens and where some of the most consequential conversations in Washington begin. I'm Mike Balsamo. I'm the 118th president of the National Press Club and the national law enforcement editor for the Associated Press. A year ago, Donald Trump was elected president, and immigration enforcement was one of the signature promises of his campaign. Since taking office, the administration has moved quickly. Border security efforts have expanded. ICE operations have intensified across the country, and detention facilities are holding significant numbers of individuals awaiting their cases to be heard. In July, through what was called the One Big Beautiful Bill in Congress, approved a major expansion of the immigration court system, increasing the number of immigration judges to 800 and adding an equal number of judge teams to help address a backlog of more than 3.4 million cases. That was meant to strengthen capacity, but according to records maintained by the Judges Union, the opposite has happened. The total number of sitting judges has dropped to roughly 700 at the start of the year to about 600 today. The International Federation of Professional and Technical Engineers, IFPTE, and its affiliate, the National Association of Immigration Judges, report that since January 20th, 82 immigration judges have been dismissed without cause. That number includes 11 associate chief immigration judges. Many others have stepped away through early out offers or through retirement. Regardless of political views, these developments raise fundamental questions about how the immigration courts are functioning, how removal protection for judges have changed, and what it means for judicial independence when military judges are trained to serve temporarily on the immigration bench. These are not abstract issues. They affect families, due process, and the integrity of a system millions of people interact with. To help us understand this moment and what it means in real time, we're joined by a panel with firsthand experience. Anand Petit served for 2 years as an immigration judge at the Annandale, Virginia court before her dismissal without cause in September. Prior to her appointment, she worked in private practice and taught law at Georgetown University. Emmett Soper was an immigration judge for 9 years in a Virginia court before his termination without cause in August. His service at the Department of Justice began in 2005, where he held several roles before joining the bench. Ted Doolittle served as an immigration judge in Hartford, one of only 2 judges on that court before his termination without cause in September. His career spans both public and private practice, including 6 years as Connecticut's healthcare advocate. And this may feel familiar for Ted. He previously worked here in Washington as a reporter for State's News Service and was a National Press Club member. And joining them is Matt Biggs, president of IFPTE, representing more than 90,000 highly skilled workers in the public and private sectors. The National Association of Immigration Judges is an IFPTE affiliate. We're grateful for each of them being here today to share their experiences and perspectives. We've already received some questions in advance, and you'll find question cards on your seats. If you have questions during the program, you can just fill out a card and pass it to a staff member standing here in the room. We'll try to get to as many as time allows. For those who are watching on our live stream or on C-SPAN, you can send questions to headliners@press.org with the subject line, Judges. All right, let's jump on into it. Ted, why don't we start with you? For people who may not follow immigration issues closely, can you talk to us a little bit about how the immigration court system is structured and how the role of an IJ fits into that structure? And maybe you could compare it to a court system that people might recognize, a state court system, for example, and just give us a sense of scale and responsibility.
Okay, so in terms of scale and responsibility, there's currently supposedly 700 or 800 vacancies for IJs. I think 600 of them are being filled. The backlog is tremendous. The last I heard was 3.4 million. I know that in Connecticut, when I left, several judges had taken the early outs that were offered by this administration. So there were 2 judges for 46,000 cases. So the caseload is crushing. I think it's probably one of the most overburdened court systems, state, municipal, or federal in the United States. In terms of comparison with, say, a state court system, in my home state of Connecticut, the judges are quite independent. They're appointed to an 8-year term by the governor with the approval of the legislature. In the immigration court system is quite different. It actually, believe it or not, Mike, is part of the Department of Justice. So the immigration judges wear black robes, they sit up on a dais, but at the end of the day, the tenure is very similar to any attorney in the Department of Justice. And one thing that is highly unusual is that the judges' opinions can be reviewed and indeed changed by the executive branch. The immigration judge's decision can be appealed to an entity called the Board of Immigration Appeals, and then it goes up to the regular court system that goes up to the United States Supreme Court. However, the Attorney General of the United States, believe it or not, is entitled to pick out any IJ decision, immigration judge decision, or any appellate decision and affirm it or reverse it with a decision, so that you literally have the Attorney General of the United States able to overrule the courts and in fact issue a decision that can be binding precedent on all the judges, 700 judges around the country. Now, the Attorney General of the United States, of course, reports to the President. The prosecutors in immigration court are called Assistant Chief Counsels. They work for the Department of Homeland Security. So you have the prosecutors who report up to Secretary of the Homeland Security, which is now Kristi Noem, and her boss as well is the President of the United States. So it really does lack structural independence. Now, historically, the immigration judges have been allowed to decide cases as they see fit, but in terms of the underlying structure, it's not independent at all.
And so, Anand, maybe you can talk a little bit about what do you see as sort of like the biggest misunderstanding the public has about what immigration judges actually do?
Sure. So Judge Doolittle hit one, which is that we're within Department of Justice. That's a big misunderstanding and misconception. People believe that immigration courts function with judicial independence, the same way that we think of most courts in this country, and immigration courts just don't have that sense of independence that most courts do. I think another misunderstanding or thing that people might not know about is just the backlog. This is obviously being spoken about more, but there is a crushing backlog in immigration court as well. There are not enough judges to hear those cases, and this administration is taking it upon themselves to fire a lot of experienced and trained judges who can hear those cases and can mitigate that backlog. And then just one last point that I'll make is that there is a constitutional right to due process in immigration court proceedings. Every person, regardless of their immigration status and lack thereof, is entitled to due process in our immigration court system. And that's one of the tensions that we're seeing play out right now is we have this backlog and we have an administration which is putting a strong emphasis on case completions, but we need to balance that against the constitutional right to due process that every person has in immigration court. And that's the challenge with mitigating the backlog, but due process needs to be a part of the conversation.
And so, Emmett, maybe you could sort of like set the stage for us. You all were immigration judges for the majority of the past year. Before the sort of recent staffing changes, what did a typical docket look like in terms of cases, preparation time? What does a hearing actually involve? Like, can you just walk through that process?
Sure. So immigration judges typically conduct two kinds of hearings. We conduct preliminary hearings, which we call master calendar hearings, which are typically pretty short hearings, where if a non-citizen is represented, we'll speak briefly to the attorney, learn some basic information about the case, give the attorney a chance to file any applications for relief, like an asylum application, and then we'll usually schedule a longer hearing at which we'll hear the non-citizen's testimony, consider their documentations, and then make a decision on their case. These longer hearings are called individual calendar hearings. They typically last anywhere from, let's say, 2 to 4, even 5 hours. They consist usually of detailed testimony from the non-citizen. Where a non-citizen is represented by counsel, counsel will usually submit quite a bit of documentation in support of the application, which is often an asylum application. Having heard the testimony, the immigration judge will usually hear some brief arguments from both attorneys, the non-citizen's attorney and the opposing counsel, the attorney who represents the Department of Homeland Security, who functions in essence as, you could say, the prosecutor in immigration court. Having heard arguments, the judge will usually consider the case for a little bit and then issue a decision. Sometimes judges issue decisions in writing. More common, though, is for the judge to take a little break, come into the courtroom, and then issue an oral decision outlining the facts of the case, whether they're granting or denying the application, and giving their legal rationale for how they are deciding the application. A lot of the cases the judges have are very complex, and these oral decisions, they're not short. They can last anywhere from 20 minutes up to 45 minutes or even an hour.
Sure.
Often a relatively long oral decision is necessary to cover the legal complexities and the factual complexities of the non-citizen's case.
So I'll throw it up to any of you here. The justice system has a reputation for being slow moving, right? There's delays in the immigration court may not be shocking for many Americans, but you know, as Ted said, we're talking about a 3.4 million case backlog. What does that mean inside the courtroom? Like, how does that backlog essentially shape decision making and case scheduling, and talk to us a little bit about the efficiency within the court system when you're dealing with a massive backlog like that?
So just to jump in, I know in Hartford that I was terminated in September of this year, and I think the staff were giving out trial dates into 2027, and that's due to the fact that at that time there were 2 judges in Hartford, Connecticut, and even it's unbelievable that an immigration case trial takes 2 to 5 hours. That's a small amount of time to decide somebody's life, but you have if you can only do maximum, I would say, 3 of them in one day, and that's pushing it. I mean, really, you should only have to do 2 because, as Emmett says, the decision that you have to dictate so that you don't have to wait for a written decision, so you do it faster, you're going to dictate it, but that takes up to an hour or more. So when we're talking about the big beautiful bill providing 10,000 agents and 100 new judges, that balance is off. To me, and I was a former senior executive in the federal government, if you really wanted to get the backlog down in a reasonable time, say 2 or 3 years, you should be talking about between 2,000 and 3,000 judges to get that number of trial dates. Most of these folks are not going to gain asylum. Most of those cases are going to be denied, but they all, as Judge Petit mentioned, are entitled to a fair hearing, and we're not giving them that opportunity. If we want to speed this up, Mike, in my opinion, one of the things to do is to devote resources. You want to devote it to ICE agents, that's fine, but they need defense attorneys, because if you are appearing pro se without an attorney, you, the judge, have to take multiple hearings to explain to them the complexities. A respondent with a 4th grade education doesn't know what corroboration evidence is, and you have to have a hearing to explain that to them. If they have an attorney, you don't have to have that hearing, because the trained attorney will know that. So if the idea is to speed up these cases, to me, we got to start having a conversation about either, in the model of federal public defenders or court-appointed counsel. That not only would protect the rights, it would also speed the calendar up.
Yeah, just to add on that, and I do agree with all that's been said. I mean, there aren't enough hours in the day to do everything that an immigration judge has to do. We have master calendar dockets. You have a minimum of 25 cases. Sometimes it can be as high as 50 cases, and you have to go through these cases in an efficient and organized way, but also provide the necessary statutory advisals.
In multiple languages.
In multiple, yeah, you can have a docket with 5 different languages,
Yep.
and then you have to manage interpreter orders and in-person interpreters, video interpreters, telephonic interpreters, make sure all of your orders are correct and that everyone is getting the language that they need. need. So you have to be very efficient. That takes time. Something we were talking about earlier was how long it took us to really feel confident in managing our dockets and being efficient. And it does take time. It's not something that happens overnight. It's not something that happens the day after your formal training. And then on top of that, there's a lot of out-of-court things that we have to do, but we're in court so much that it's difficult to find that time to adjudicate motions, to work on our oral decisions, to work on our written decisions, to do legal research. You know, there's so many new decisions, new policy memoranda that we have to bring ourselves up to speed with, and so it just takes so much time. There is an emphasis on completions in this administration. There has been an emphasis on completions in other administrations as well. And I do believe that there is a universal interest in reducing the backlog. Even asylum seekers and people who are in immigration court proceedings for whatever reason have an interest in resolving their case. You know, if someone came in and has a fear of persecution from Colombia, you know, evidence can get stale. It gets harder and harder to find documentation the longer time has passed. People's memories fade. It's harder for them to testify about something that happened to them many years ago versus it being fresh in their memory. So when we talk about the backlog, we need to talk about it as a bipartisan issue. This is something that is to the benefit of everyone who has to interact with the system.
I agree with what my colleagues have said. I think that when it comes to reducing the backlog and speeding up the immigration court process, to a large extent, it comes down to resources. Mm-hmm. The more judges you hire, the more law clerks you hire, the more support staff at the courts you hire, the more hearing slots will be available for these cases, and the faster the cases will go, the shorter the waits will be for somebody to get their individual calendar hearing at which they'll testify and the judge will decide the case. So I think to a large extent, it really comes down to how many resources the government is willing to invest in the immigration courts. And I'll make one more point, which is that the unlawful firings of immigration judges are exacerbating the backlog because each immigration judge is responsible for hundreds or thousands of these cases. And every time the administration unlawfully fires an immigration judge, they're no longer there, their cases have to be redistributed to the judges who remain at the court. It's a huge amount of work for court staff, and that is how hearings are getting delayed. This is happening right now. The unlawful firings of immigration judges are exacerbating the backlog. It means that people have to wait longer for their hearing, and it means people have to wait ultimately longer for the resolution of their case.
And to Anam's point about bipartisanship, hiring immigration judges and providing due process to those that appear before immigration judges is a bipartisan supported issue, at least it was in the Congress. You know, Senator Lankford last year, when then candidate Trump was running for office, he had a bipartisan bill moving through Congress, and you know, some people liked it, some people didn't, but it was going to pass, and Trump himself sunk that bill, I will note. And then in the budget reconciliation bill, the big beautiful bill, there wasn't much beautiful about it actually, but they did call for increasing the number of immigration judges to 800. And that was a partisan Republican bill, by the way. So they're you know, Democrats and Republicans on the Hill, from the right to the left, agree that we need to bolster up the immigration judge corps. You know, and we should shift some of those resources from ICE agents to hiring more judges. But you know, you can do the math pretty easily. Each immigration judge, on average, handles about 500 to 700 cases a year. We have a 3.4 million case backlog. We need to hire a lot more than. We need to have a lot more than 800 immigration judges. We need to have a couple thousand immigration judges. And you know, whether this administration likes it or not, with all the illegal firings and all, you know, immigrants in this country are entitled to due process. And by firing these judges, you're denying them their due process. And it's not a stretch. If you're denying immigrants due process, it's not too far of a stretch to you start denying your own citizens due process.
So I want to come back to a point you made about, you know, when a judge leaves suddenly, whether through termination or retirement or taking these sort of early outs, Can you talk a little bit more about what happens to those, hundreds or thousands of cases that have been assigned to them? And I think you touched on this a little bit, but the practical effect for, folks who are already waiting years for their case to be heard before a judge. What does that look like practically when that happens?
Well, in the courts, the unlawful firings of immigration judges really leads to a chaotic situation because people at the court, they don't know when this judge or that judge is going to be fired. It's a surprise not just to the judge, but to everybody who works at the court. And what that means is that the people at the court who are responsible for scheduling these cases, and it's a very, very big job, are all of a sudden just presented with, let's say, 500 cases that all of a sudden don't have a judge and have to be rescheduled. This is done with no notice. It's always a surprise when this happens. It leads to a huge scramble to reassign all of these cases to the judges who remain at the courts. And from the point of view of a non-citizen who has a trial date, who has a case pending before the court, it throws everything into chaos. As you can imagine, a non-citizen with a case in front of the court is probably very nervous about their hearing, spending a tremendous amount of resources to plan for the hearing, plan what they're going to say, gather evidence, etc. They're often basing their whole lives around this upcoming hearing, which is going to decide whether they have the right to stay in the United States or not. When all of a sudden they learn your judge has been fired, it's not clear what's going to happen with your case. It delays justice, it delays a resolution in this case. It's tremendously upsetting, understandably, for a lot of the non-citizens who appear in front of the court. And leaving aside the sort of administrative inefficiency of all of this, it's just not fair. This is not a fair way to run a court system. It's not fair to the people who are at the court. It's not fair to the judges who inherit these cases. And most importantly, it's not fair to the people who have cases pending in front of the immigration courts who depend on the immigration courts being a functioning system.
And if I can just add quickly, because Judge Soper and I were at the same court. He was let go in July, and I was let go in September. So I was there in the subsequent months. I mean, Judge Soper's termination shocked the court. It shocked more than just our court because he had years of experience. He was a very respected judge, and no one saw it coming. I think it was in the middle of the week, in the middle of a pay period. It just kind of deviated from a lot of the firing patterns even in this administration. So it was debilitating for morale at the court. Judges felt it, staff felt it, and the unexpected nature of it just made it that much more difficult because no one really felt safe. I felt a little bit more on the chopping block because I was a probationary judge, so it was easier to fire me legally, but Judge Soper was not a probationary judge, so even judges who had long tenure on the bench felt uncomfortable with that. And then on a more back-end procedural matter, his docket was just left. No one really knew what to do with it. Staff was already so overburdened. So even though he had a legal assistant and a supervising legal assistant, they're managing a lot of other judges, a lot of other dockets as well. So you had pending oral decisions. Those were kind of farmed out to different judges. You were very prepared, so that was helpful for handing off the case. Those decisions came to me. I never got around to them because then I was also let go in September, so that those decisions are now going to get transitioned away again. I received some of Judge Soper's motions, but they came to me 1 or 2 months after they were filed. So they were just sitting, motions to change venue, motions to continue, motions to terminate or administratively close a case. These are substantive motions that can really resolve the case on the merits, or they just need a more, they need a judge to look at them quite quickly. And that just wasn't happening because the courts are just so overburdened. And this is happening across the country. More judges that are fired, this kind of reset is happening in every case. And as I've heard, justice delayed is justice denied. So, these cases are definitely getting affected.
Well, let me comment just briefly on how these firings are being carried out. So I was a probationary judge. In fact, Anam and I trained together. Also, in my probationary period was coming up in September of 2025, September 24th of 2025 was my anniversary. So I had just completed master calendar with about probably 30 folks and was preparing for the next day's master calendar where I was going to see 57 people. I received an email at 3:16 p.m. and attached to the email was a PDF that it contained almost no information except that the Attorney General of the United States, under the powers vested in Article 2, had determined that my continuation was no longer in the best interest of the country, and I was to turn in my key and my equipment by the end of the day. And my system access was turned off about 75 minutes later. It wasn't completely unexpected because some of the July probationary judges had been terminated, so I gathered the staff, and I had been preparing the staff for the fact that this might happen. But I gathered the staff and said farewell to them, asked them to make a few banker's boxes for me, and I put my stuff in my car and rolled out of the courthouse garage, handing my PIV card, that the card used to get in and out, to the one remaining judge in Hartford, who now was responsible for 46,000 cases.
And, along those lines, did you both experience something similar? I mean, can you talk us through what that process looked like? Were you given a similar written explanation, that same sort of letter from Pam Bondi, and how did your colleagues learn what was happening?
So I had a similar experience to Judge Doolittle. I think my email came at 3:34 instead of 3:16. I was in the middle of hearings. I had just given an oral decision in a pro se matter. I was about to give an oral decision in a continuation of another case that I didn't have enough time to do a couple of weeks ago. I did feel like it was coming because I had seen what had happened with the July judges. I had a private practice background and also in academia prior to becoming a judge, looking at kind of trends and who's been fired and who hasn't been. Coming from a private practice immigration background puts a little bit more of a target on your back as far as being let go. And I knew it was coming down to the day because there's been a trend for it to be the Friday of the pay period before your 2-year anniversary if you're on probation. So that's how it played out for me. And I received the email. I gave the second oral decision that I had to. I called my husband afterwards and I cried, to be very honest. I was devastated. It was a dream job for me. And even despite all the adversity and the hardships, and even a little bit of optimism I was still holding on to not get fired, I was devastated to lose a job that I really believed in and made a lot of professional and personal sacrifices to do. I had packed up my office. I got help from some judges and support staff, and they helped wheel it out to my car. We just took out my items from the car about 2 days ago because we had to drive up to Pittsburgh and we needed the trunk space, but I haven't had the heart to even take my robe out of the car and unpack my boxes. And yeah, it was difficult. I've gotten a lot of support from my former IJ colleagues who I'm still in touch with, and staff. I've gotten a lot of emails, a lot of texts, and a lot of calls. There's a lot of camaraderie at the court. They're great people. My faith is in them to uphold the system and the due process that everyone is entitled to. And that's one of the things that I miss the most, is just working with great people who made a very difficult environment with this administration a little bit more bearable, because you believe in them to do what they're supposed to do.
Yeah, so the day I was fired, it was a Thursday. I was sitting in my office working on a written decision. I looked up, it was about 4:15, and I had an email from the acting director of the immigration court system, and the subject line was termination. I opened it up. It was maybe a 1 or 2 sentence email, and there was an attachment. I clicked on the attachment, and the attachment was the letter officially telling me that I was terminated effective immediately. It gave no reasons. It was a very short letter, maybe 2 or 3 sentences. I, at the time, had been an immigration judge for over 7 years. I had served as counsel to the director of the immigration court system. And before becoming a judge, I had worked for years in various roles in the Department of Justice and within the Department of Justice in the immigration court system. Despite all of that, I was terminated, no warning, no explanation, via a 3 or 4 sentence letter. About maybe 45 minutes after I got the letter, I got a call from my immediate supervisor to talk about logistics. Who do I give my computer to? Who do I give like my building pass to? Things like that. I asked him point blank, why am I being fired? And he responded, I don't know. I just found out about this a couple hours ago. I had been a Department of Justice employee at that time for almost 20 years. I got fired with no warning nor explanation, and my supervisor could not begin to give me any sort of an explanation as to why this happened. That's how the immigration courts are these days under this administration. It's not how it's supposed to be. It's not legal, but that's the reality that we're dealing with.
I'll just say too, as the union president, we represent a lot of federal employees. Federal employees in this nation are under attack, right? These folks are all judges. At the end of the day, they're federal employees, they're workers. They have families they have to take care of. They have to provide for them, provide health care, provide a roof over their head. And to fire these judges and federal employees, period, that have decided to work for the federal government and serve the American taxpayer. They could go elsewhere and work, but they decided to serve the American taxpayer. These are highly skilled lawyers here. They could go work anywhere else, probably make a lot more money. They decided to serve the American taxpayer, and it's shameful for this administration to treat dedicated public servants this way. It's absolutely shameful. And it really begs the question, who would want to work for Donald Trump and his administration? Pam Bondi firing people? Give me a break, with all due respect. It's really deplorable.
Mike, if I could just add, so under a relatively new process instituted by OPM, the personnel agency for the U.S. government, when a probationary employee is terminated, they get what is in effect a performance evaluation that's supposed to be performed and created 60 days before the end of their probationary period. In my case, I got a performance evaluation on July 24th from my supervisory judge, 60 days in advance of my end of my probationary period on September 24. I've been an attorney for a long time. I was proud that this was probably the best performance evaluation I'd ever had. It mentioned that I was, case completions, Anam has mentioned, were targeted at 700. I was set to hit 2,100 for the fiscal year, so about triple of what they demanded. There was not a negative word in this performance evaluation, and the judge strongly recommended that I be retained. So I have no doubt that Judge Soper and Judge Petite's terminations were also not performance related, but I have the receipt in my case that establishes that it's not performance related in many of these cases.
So Matt, I want to come back to a point that you made. So in September, you told ABC News there was a trend of judges being fired, having been originally appointed in the Biden administration. Are you continuing to see that trend? And you talked a little bit about this, but how do you see these firings as a political act in this administration?
Well, initially they did appear to be political, and they probably still are political. I think the lion's share of the judges, I haven't looked for a while, but the lion's share of them that were fired were hired during the Biden administration, probationary judges. Emmett, however, doesn't fall into that category. He's judged for 7 years, but yeah, we can see it. I mean, we're almost a year into this administration, and they seem to use the government, the levers of government, to go after folks that appear to be political opponents of theirs, right? So these judges that have been fired, A lot of them, at least initially we were seeing, were hired during the Biden administration. I will say this, though, the one area of the government you would think, given then candidate Trump, President Trump's campaign rhetoric to strict enforcement of immigration laws, you would think the one place that, with Elon Musk and Doge, and they came in and just started firing people and wiping out agencies illegally. But the one area you think would be exempt from that would be the immigration courts, and that has not been the case, unfortunately.
Could I just ask a question, Matt? I noticed that we went through, Anam and I went through a very good training period, and it seems to me like when I'm looking at the judges that were terminated, not the probationary judges, it seems like all of the key trainers, Elizabeth Young, Judge Payton, Judge Wood, they've all been removed. Is that a pattern that the union has observed, that the judges involved in the training?
We've seen that, yeah, we've seen that too. And it does beg the question, what does this administration have in store for these immigration courts? Because now all of you are being replaced, at least that's what they say, with JAG lawyers, military lawyers out of the Department of Defense that have presumably no experience whatsoever in immigration law or administrative law. But before this administration came into office, just to be qualified to even apply for the job, immigration judges had to have 7 years of experience in administrative or immigration law. And now we're replacing, with all due respect to the JAG lawyers, we appreciate their service to our nation, and it's no disrespect to them, but they should not be in these positions. This is it's outrageous, it's ridiculous, and it does I mean, we see it happening right before our eyes, and all these firings, it begs the question, what does this administration have in store for these courts?
I want to come back to the point about military judges in just a second here, but I want to open it up to ask you guys a little bit about something we're seeing in the hallways of immigration courts across the country. So we've all seen the videos, people taken into custody inside courthouses or just, steps outside as they're arriving for these hearings we've been talking about. We've heard story after story of individuals who've waited years for their day in court, but never made it into the courtroom because they were taken into custody by ICE in the courthouse itself or detained on their way in or out. So from where you sat on the bench, how often did you see or hear about those incidents, and what is that kind of enforcement do to a system that, depends on people being able to essentially come to court without fear?
Sure, I can speak to that briefly. So in Annandale, it was a daily occurrence that people were getting detained in the hallways, in some cases in the courtrooms. It was typically happening at master calendar hearings, which Judge Zipper explained were the preliminary hearings, but it was also happening at individual hearings. I had a case where an individual was detained right before the individual hearing, so this case that I had prepared and likely could have adjudicated that day didn't go forward. Instead, that case went to the detained docket for a detained judge to hear the case. So again, just very inefficient from a perspective of case completions. I mean, it has a huge chilling effect. It's disturbing to the judges, to the attorneys, to the interpreters, but most importantly to the people who have to appear in court and their family members and friends who accompany them. I saw a significant increase in failure to appears on my dockets since the Trump administration. People are afraid to come to court because they're seeing people get detained in the hallways, or if they haven't physically seen it with their own two eyes or seeing it on the news, they don't understand the difference in that person's case and their own case, so they just see they're detaining everyone, and so they're not coming to court. In immigration court, if you don't come to court, there are very dire consequences. You get ordered removed in your absence. So then you're walking around with a removal order. You have no right to appeal that decision. You do have a right to reopen the case, but under very limited circumstances, and that's at the discretion of the judge. And so it has that chilling effect, and then it's disruptive to the cases that are going forward. I've heard cases where I hear people screaming and crying in the hallway because someone's being dragged away, and it's hard to testify. You're testifying about one of the most traumatizing parts of your life, right? Maybe you're talking about sexual abuse or death threats that you received or being tortured in a prison, and then you hear someone crying and wailing outside, and you're wondering, am I next? Am they going to come into this courtroom and take me away? Or also, I just can't think because I'm hearing this. And so it's just very disruptive to the entire system.
Yeah, I agree with everything Judge Petit said. ICE started at the court where we work in Annandale, Virginia, arresting people on a regular basis earlier this year, maybe in, I want to say May of this year. And when they started doing that on a regular basis, it was one of the most disturbing things I've ever witnessed. They, on a regular basis, would detain people who were showing up for their master calendar hearings, in other words, their preliminary hearings. These were people who had done nothing wrong, who usually did not have criminal records, and who were just trying to follow the rules. All they were doing was showing up to court like they had been told they had to do. We would have a master calendar hearing, the preliminary hearing, and then as soon as they would step out of the courtroom in some of these instances, they would be arrested by ICE officers and taken away. And these were not just people who were showing up for court on their own. In some cases, ICE was targeting people who were showing up for their hearings as part of a family. So you might have a mother, father, 2 kids, all in immigration court proceedings together, all show up together for their court hearing. Once they had left the courtroom, ICE would arrest the father in the family, take him away in front of his wife and their children. They were doing this on a regular basis. They were absolutely splitting up families who were simply trying to follow the rules and show up for their court proceedings as they were legally obligated to do. I don't care what somebody thinks as far as immigration policy, but I don't think there's any way from a moral or an ethical point of view to defend this sort of thing that ICE was doing. I saw them do it on a regular basis, and it was, as I said, one of the most disturbing things that I've ever seen.
And, you know, from your perspective on the bench, right, what is that like every day, right? You're hearing the cries outside your courtroom, you're watching families being separated. You know, what does that do to you, you know, both as a judge, but also as a person hearing that every single day?
I'll start. So in Hartford, Connecticut, we didn't have the daily pickups, but there was one person arrested in front of me who was apparently the ICE agents. ICE agents like to arrest people in courthouses because it's guaranteed they have no weapons. They've been through the system, so they're layups. They're the easiest types of arrest. This guy was confronted near the elevator and ran all the way back to my courtroom, making me think that the ICE agents had, you know, deviated from whatever the protocols are to corral a person, that they're apprehended. Anyway, they wound up tasing this person in the courtroom lobby directly outside my courtroom door 7 times apparently, and the cries of agony and so forth were extremely disturbing, and it went on for many minutes until they finally subdued the person and removed him. And I can tell you that many of the court staff lost sleep, like physically weren't able to sleep for a period afterwards, and of course it makes them question whether that's a job they want to continue.
Yeah, it was very difficult. You asked about our role as a judge, but also our role as just humans who have to see this happen, and I felt a tension there. There was what I personally felt morally, but then there's my role as a judge, which is what I'm there for. And we're neutral, we're unbiased, and we're fair. And ICE is a party to the proceedings that we're presiding over. So you have to be very careful to stay in your lane and to uphold those principles of fairness and neutrality. I was very careful to treat both sides equally all the time. And we would often get questions by respondents, typically unrepresented, and say, how do I not get detained? Or will I get detained, Judge? You know, and I'm not a part of that. I'm not part of DHS. I'm not part of ICE. So I have to just kind of deflect these questions, like, I'm so sorry, sir, I'm not really involved in that process. I can't really advise you or give you legal advice. I recommend that you talk to an attorney. Maybe I would talk to the ICE attorney in my courtroom, depending on who it was, and say, Mr. So-and-so, Ms. So-and-so, do you have any guidance for the respondent here? He's asking about his detention, because that's not the role of DOJ. And so that was very difficult, because we have a very specific and limited role to play. And so it kind of ends up being this big elephant in the room with ICE enforcement that's happening, that everyone knows is happening, can see is happening, but we can't really talk about too much or let it play out as far as what the judge's role is.
Yeah. We all work for the Department of Justice, and I want to emphasize the word justice. I signed up, and all of us did, to work in a court system that we thought was fundamentally fair. A non-citizen might win their case, might lose their case, but the key question is, did they receive a hearing? Did they participate in a process that was fundamentally fair, that gave them a fair opportunity to make their claim? The immigration courts have their flaws. It's always been like that. But up until this administration, I had always been confident that I was working in a system that, despite its flaws, was fundamentally fair. When I saw the changes with this administration, in particular, the fact that the leadership of the immigration courts was letting ICE make arrests in the manner that we've all described in the court's lobbies, I thought, this is not fundamentally fair. This is not the Department of Justice, and again, I'll emphasize the words justice. This is not a system that you can say with a straight face is a fundamentally fair system. I came to that realization a little bit into this administration, both at a personal and a professional level. It was a very disturbing realization to reach.
If I could just add to what Judge Soper mentioned. So the immigration laws in this country in many ways are harsh and strict and unfair. That means that all of us probably had to issue decisions that we thought were harsh and unfair because the underlying law is harsh and unfair. What Judge Soper is saying is that within that context of whatever the law might be, the person is entitled to a fair hearing. And if we're in an environment now where people are being detained and the cases are being pushed through the system much faster than it really takes to gather the evidence, now we're into a zone where a person who, even in the best of system days, might not be entitled to asylum, is not getting a fair hearing. So what I'm of the belief is that you're not entitled to asylum. The laws might be unfair. The judge might agree that the law is unfair. That means I'm going to issue an unfair decision. But you're going to have a fair hearing. And that's what's going away, is the right of these people to have their cases heard fairly. Not their right to an asylum, which they might, statistically, most of them are not going to be eligible for asylum, but they are entitled to have their cases heard fairly, and that's what's gone away, or going away.
Emmett, you've referred to all of your terminations repeatedly as unlawful terminations. Can you talk to us about whether you or any of your former colleagues are preparing to challenge those terminations, whether through legal action or through another formal process?
I've challenged mine through the MSPB, which is the Merit Systems Protection Board. It's pending. I haven't really received any news about it. I can't really speculate on the likelihood of success. A lot of us have challenged our terminations, and generally speaking, our cases are pending. Pending.
And I, as a probationary employee, had more of an uphill battle with MSPB. I did consult with several attorneys to know what my legal options were. It comes down to what is the definition of an employee, and there's some difficult law out there regarding probationary judges. And interestingly, the reason why they even hire us on temporary appointments and put us on that probation, it's historically how they've always hired judges, but historically, 95% of judges make it past probation, and you don't make it past probation if you have some egregious issues. Is because they want us to start hearing cases earlier. They don't have time to finish our security background check, and so they hire us on temporarily so they can finish our background check while we're still hearing cases, and then they convert us to permanent. So that's the reason for it, and then this administration is kind of using that legal and structural loophole to fire a lot of us without cause. But I did file an EEO complaint on several protected characteristics, including my ethnicity and race, my gender, sex, my parental pregnancy status. I had a child while I was a judge as well. And so I went through that route, and it's still pending, and it has been delayed by the shutdown.
Yeah, I should note too, with those internal processes that federal employees can exercise to challenge an adverse action, which obviously a firing is, this administration has gutted those small but very important agencies. MSPB, just up until about, a few weeks ago, didn't have a quorum. They fired the folks on the MSPB. The chair of the MSPB, when she got fired, she challenged her firing. They've gutted the very agencies by which federal employees that are victims of adverse actions, in this case, I'll just say politically motivated adverse actions, can exercise. So as a union, IFPTE, we are working with Congress, hopefully get a bipartisan bill. If it hasn't been introduced already, I've kind of lost track of it, but I know Senator Schatz is, he's pushing a bill to allow federal employees to go straight to the federal court, go into the federal courts in an instance, a circumstance where you have an administration that purposely fails to appoint folks to places like the MSPB and the EEOC.
I want to come back to the point earlier about military judges here for just a second. So hundreds of military judges and lawyers are being trained to serve temporarily on the immigration bench, but now that those lawyers have begun, conducting hearings, what concerns, if any, do any of you have about them adjudicating immigration cases from a due process perspective, from a labor perspective, and are there elements of the work of an IJ that JAG lawyers may not necessarily be equipped to handle?
So if I can start, I believe in the Hartford Immigration Court, one of the JAG judges is in place. As I mentioned, when I left, I was there were two full immigration judges there, and I understand it's an abbreviated training period that he is in, but after he gets out of that probationary period, that training period, there's going to be a lengthy period which lasts much more than a year, where you're going to be being taught by the other more senior judges in Hartford or in Annandale, wherever you might be. And so many's the time where I took a break in a difficult case, went and talked to another judge, got some input, and went back. The new JAG judge in Hartford, Connecticut, is not going to have 4 judges to go to. There's going to be 1. And in a way, the new judges are going to be much more on their own, because these senior judges either have been removed, like Judge Soper was, or they've taken the fork in the road options, or there's voluntarily early retirement. Anyway, the more senior mentoring judges are now gone. So the JAGs are much more at sea than they were previously.
Yeah, and my concern with the military lawyers isn't that they don't have immigration law experience. EOIR has historically hired judges without significant immigration law experience, as long as you have other comparable experience, such as in litigation or administrative law. Judge Doolittle didn't have significant immigration experience before becoming a judge. He was an exceptional immigration judge because he received the training that he just explained. So my concern is that on 6-month stints, these military lawyers are not going to get the training that they require to be competent and qualified immigration judges. It is not just formal training where you're in a classroom, we call it judge school. You also get a lot of mentorship on the bench. I worked with multiple experienced immigration judges. I shadowed them, they shadowed me. There were a lot of training wheels. And so if they're only doing these in 6-month stints, like at a minimum, that's when you start feeling comfortable as an immigration judge to operate with efficiency and fairness. Like, we work so many technology systems at the same time, which people don't realize. I'm like writing my notes, but I'm also looking at the electronic case information. I'm also recording for individual hearings. I have no legal staff with me. I've literally had to call IT with parties in front of me still on my board being like, hey, this isn't loading the way it is, and I need to make sure that this is getting recorded, because that's a automatic remand at the board if there's no transcript for the case. So there are a lot of hats that we're wearing, and it takes a long time to really feel experienced. You know, at 2 years, we were really starting to hit our stride, and then you get laid off, and they're going to bring in these judges on just very short 6-month rotations. By the time those judges are starting to feel a little comfortable, they're going to bring in the next wave and just hit the reset button. And so for an administration that is trying to be efficient, right? The whole point of this is to do cases quickly and complete them. It is not efficient. This is going to lead to more denials that are legally flawed. It's going to lead to more appeals. It's going to lead to remands that come back to judges, and it won't even go to the same judge that heard the case. It's going to go to the next military judge who's there, or another judge who's a permanent judge there who has to pick up the extra work. So it's just a very inefficient proposed solution.
Just to real quickly add on, so as Matt was telling us earlier, the judges who were responsible for doing the training for many years have been removed. So the trainers are new too. So, you know, you've got new training corps trying to teach judges out of the JAG corps, all respect to them for their abilities as attorneys, but they're not given the time to come up to speed.
Yeah, I echo everything my colleagues have said. It's a very, very challenging job being an immigration judge, and until you've done it, it's hard to really understand just how challenging it is. It was a very rewarding job, but it was also far and away the most challenging thing that I've ever done professionally. It's not something you pick up in a matter of weeks or even months. When I started as a judge, I was told by other judges that it would take me roughly 2 to 3 years as a judge to become fully comfortable on the bench deciding cases, and honestly, that proved accurate. You can know the law, you can know basic courtroom procedure, but you just have to get in there and do it and see a whole bunch of scenarios and figure out, this is how I'm going to react when this thing happens. This is how I'm going to react when that thing happens. And it really takes a couple of years until you've done it enough, until you've seen enough where you're really comfortable in your role as a judge. Regardless of how well-intentioned and motivated somebody is, it's not something you can pick up in a few weeks or even a few months. So I have no reason to question the integrity of the military judges who are starting, but they're just not being set up for success.
Yep.
And so before I ask the final question here, let me just take a moment to thank our headliners, team leader Jen Judson, Jamie Horwitz of our headliners team who helped organize today's discussion, the club's executive director, Didier Soji, our membership program manager, Cecily Scott Martin, and all the club staff for making this event possible. Thank you again to our audience for being with us today. I also want to present each of you with the signature National Press Club mug as a token of our appreciation, if you will pass them down here.
Of course.
Oh, that's fancy.
Yeah.
Thanks.
Thank you.
Thank you.
It's like a gifting service over here. And so before we close, I want to ask each of you this question. So what do you want the public to understand most about this moment in the immigration court system? Something they may not be hearing anywhere else, something from you directly here. And looking ahead, when we reflect on this period years from now, what do you hope people will remember about what was at stake?
Well, as has been mentioned several times, you're not entitled to asylum. You are entitled to a fair hearing. And when you're degrading the number of judges, releasing the experienced judges, And day by day, you are narrowing the judges' options. Now I'm concerned that the judges are not able to give a fair hearing to each person in front of them. Again, they're not entitled to relief. They are entitled to a fair hearing, and that is going away.
So my one point would be that immigration courts need to be independent. We need to be an independent judiciary, Article 1 or Article 3. We need Congress to help us with that. And it's not a partisan issue. This is something that Democrats and Republicans should agree with, because whoever's in the White House and whoever is the AG has so much power over the immigration court system, and that results in a lot of legal whiplash based on who's in the White House. And that just makes the whole system so tenuous. It's a structural defect that has existed for a long time. Judge Soper mentioned that the system has always had flaws, and that's always been the case. But then when a certain administration comes around, they're able to exploit all of those structural flaws. And then in 3 years, if we have a different administration, everything's going to be rolled back. How can a system where the stakes are so high, right? We have life and death consequences for many of these cases, be at the whim of political impulses. And the only way to protect that and keep it from happening is for the court to be an independent judiciary.
Yeah. There are a lot of very, very good immigration judges who remain in the system, who know the law, who are people of real integrity, and who try their best to follow the law and also be fair in very different circumstances. The issue with the immigration courts now is not an issue with the judges, it's an issue with the leadership of the immigration courts. The judges who are at the immigration courts are doing their very best in very, very difficult circumstances. They are not the issue here, and they deserve to be supported.
I'll just say, 2 or 3 years down the road, we'll see how these immigration courts look. But right now, with this administration and the folks that are in leadership positions, they need oversight. They need, we need this Congress of the United States to provide proper oversight of what's going on in these immigration courts, because we in this country, in America, we're compassionate people. Our policies are about compassion, and denying due process to immigrants is not compassionate at all. It's the opposite, and due process is at stake, not just for the immigrants but for all of us. And in this Congress, which is run by Republicans, they run the whole show. And I know Republicans, we talk to them, we're a bipartisan union. They're as concerned as the Democrats are, but they need to step up and take on this administration, provide oversight, and get this immigration court fixed, because this administration is destroying the immigration courts.
Thank you all for being with us today. Thanks for a really great conversation. Thank you all for being here as well.
Thanks, Mike.
Thank you.
Thank you.